Hello, and welcome back to Regional Counsel, presented to you by the Singapore Academy of Law. My name is Nicole, and I'm your host for today. Regional Counsel is a series of short video podcasts on legal content catered to in house counsel who are new to ASEAN regional work. The series is not meant to be a deep dive, but to equip in house counsel with tips and tricks from experts of Indonesia law themselves to navigate the challenges faced when dealing with jurisdictional specific quirks. In today's episode, we'll be delving into the selection of governing law with Kalfin, partner of Jakarta-based law firm Arianto Partners.
Thank
Welcome,
you.
Mr. Kalfin.
Thank you, Nicole, for having me here.
Yeah, we're very glad to have you here today. Today, let's start off with a good discussion on Indonesia contract law.
Please, we'll be happy to help and we'll be happy to share about one of the basically insight on the Indonesian law, particularly on the contract development and execution.
Okay. Yeah, we know that you have more than a decade of experience as in-house counsel in Indonesia.
Correct.
So would you tell us today about contract formation in Indonesia?
Okay. Basically, in making customize the clause for the dispute resolution and the choose of dispute resolution is quite crucial in terms of the cross-border transaction, particularly when you put it in a contract. That is something that's probably quite important to note
Okay.
for the legal counsel to make sure that the contract already have a sufficient in terms of in the case that something happened with the contract, they already have a place of dispute resolution that can be considered as neutral,
Yes.
that can be considered as a cost efficient, and also by looking at the enforceability itself.
Okay. And is there a country you would recommend to put for the choice of governing law?
Okay, so basically in terms of doing a governing law, we have seen quite a bit of few countries. One of it is Singapore.
Yes.
And I think we also see England law is commonly being used.
Okay.
But then again, if we are looking at a certain transaction, a party sometimes they keen to have a certain governing law or dispute resolution, like something that they are comfortable with. But it really the role of the in-house legal counsel or the lawyer is to make sure that everyone interest is being covered, and also that the objective of having a neutrality, cost efficient, and enforceability is being achieved.
Okay.
I think that's the main point for that, Nicole.
Okay. Are there any benefits to, for example, having Indonesia law as the governing law?
Of course, I think in some of the contract, if you have a contract that is based on Indonesian governing law, the friction between in the case that there's a friction towards the prevailing regulation that is existed in Indonesia, for instance, for the engineering procurement construction contract, right? There's the whole lot of regulation that actually govern those kind of activities. To avoid any kind of frictions or any kind of problems in the future, we would also advise that for a certain transaction we follow the Indonesian law, but for other type of transaction we may use other law. So then again, I think the key point will be how the legal counsel or the lawyer going to indicate or basically identify what is the correct dispute resolution and the governing law for the nature of the contract.
Okay. So the nature of the contract will be key to
Correct.
choosing the choice of forum for
Correct.
the governing law in the contract
Correct.
clause.
So
Okay.
that will be the key, and most likely the parties of the contract comfort is also something that the legal counsel need to see,
For
right?
sure.
Because at the end of the day, we need to support the business.
Yes.
We need to support the objective.
Yeah.
And then again, we also need to give them some sort of protections.
Okay.
Yeah.
And assuming the business of the contract is conducted within Indonesia, would neutrality
Yes.
of the choice of forum be important, given that the business is conducted in Indonesia?
Okay. If business conducted in Indonesia involving two parties, Indonesian parties, of course, it will be quite beneficial because both parties at Indonesia and the business is at Indonesia.
Yes.
And in terms of in the case worst come to worst, something happen and they need to go to dispute resolution route,
Mm-hmm.
execution wise is something that is more straightforward.
Okay.
But however, if we see that this is a cross border transaction
Yes.
and using Indonesian law, so basically it's going to be based on the nature of the transaction itself,
Yep.
and also based on the comfort of the
Of the parties.
it's the parties.
Okay.
So it's gonna play a good role, and
Mm.
that's why I'm saying that identifying the contract objective
Mm.
or the business objective to be in line with the contract is very very important for the legal counsel and or the
Mm.
lawyer to see
Okay.
the contract itself. Yeah.
Okay, thank you very much. So,
You're
what I'm
welcome.
hearing from you is that basically the nature of the contract is very important.
Yeah.
Parties' objectives are crucial to choosing where the forum of the dispute could be
Correct.
potentially, and also that relates directly to the choice of governing law.
Correct.
Okay.
Correct.
Thank you very much on that. May I just
You're welcome.
expand on this then? Would you have any comments to say about enforceability of contracts
Okay.
in Indonesia?
Okay. In terms of, let me take a step on the position whereby enforceability in the scenario whereby the dispute resolution is being done outside of Indonesia
Okay.
by utilizing either Indonesian law or other countries' law. By fact that if you go to the route of dispute resolution via court, enforcement in Indonesia is going to be very quite difficult.
Okay.
But however, there is a very positive route that you can take. It's through an arbitration.
Arbitration.
So since Indonesia actually recognized arbitral award,
Mm-hmm.
so the enforcement of the arbitration is can be done through exequatur.
Okay.
So in a way that those kind of procedure is something that is doable.
Okay.
Yeah. When you seek for a certain certainty of execution,
Mm.
of course, there's a whole lot of dynamic to that because
Mm.
execution is somewhat is the key of the result of a dispute
Mm.
resolution or the result of a certain ruling or verdict.
Yep.
So, how are we going to basically run the verdict or the ruling, and what can we execute?
Mm.
So that is why it is very crucial. Also, it's coming back to the first discussion that we have in regard of choosing the place of dispute, choosing on the basically on the governing law.
Mm.
You need to think about the enforceability also.
Yes, for sure.
Yeah.
Yeah, the enforceability
Yeah.
of
So
it.
there's a lot of factors to be factored in.
Okay.
And of course, we have managed to help our client in terms of navigating through this type of matters.
Okay. For the benefit of our listeners here, what would be one factor for the enforcement of a contract under arbitration, for example, that they would like to know, or it would be useful for them to know?
One factor, there's no factor, but I think what we are looking at is the process. So the process will be upon receiving the decision from the arbiter, and Indonesian counsel need to submit that decision and basically done the process of exequatur.
Mm.
So that is the main point.
Okay.
Yeah.
Okay.
And afterwards, again, there's a process that need to be taken.
Okay.
Yeah.
And as you shared that
Yeah.
arbitration would be more preferred than, for example, litigating in the courts, as you earlier mentioned, because there are some difficulties with litigating. Would this be specific for commercial contracts only or to all types of contracts in Indonesia?
I'm not saying it's difficult, but I think about is something that is what is being recognized in Indonesia. So arbitration, since Indonesia recognized the decision of arbitration, so most likely that route is something that we should take. Right?
Less friction, you would say.
Yeah,
Okay.
to have a less friction.
Mm.
So in that sense, that what type of contracts? When you say that, what type of contracts? I think it going to be quite a lot of spectrum on that level. There's going to be, you know, surface type of contracts.
Mm.
There's going to be sales and purchase.
Mm.
You know,
Yes.
there's I think there's quite a bit of contracts that may relate because
Okay.
at the end of the day, each of the contracts have the potential of a dispute.
Mm.
And in the case that one party doesn't fulfill the obligation to the other party,
Mm.
I think
Okay.
that's the
Would it be beneficial for them to draft in an arbitration clause within their contracts as opposed to just having, usually the standard clause, which is to for the dispute to be taken to the court?
Okay. Oh, that will be depends on the basically the nature of the transaction itself. So even though that the contacting party is Indonesian and foreign entity, what is the nature of the transaction and where is the transaction is being happen,
Okay.
right? So at the end of the day, what you want to seek is the execution ability.
Okay.
If the party is one Indonesia and one is foreign, but the deal is doing it at some other country,
Mm.
I would advise to go to that country, right, to have a dispute court resolution, just to be sure.
Okay.
But that is my personal opinion.
Okay.
But however, we have seen the trend that some of the agreement that we are looking at is leaning toward an arbitration, whether in Singapore,
Mm-hmm.
whether in Hong Kong, whether
Mm.
in London. So it's leaning toward an arbitration because of various reasons
Mm.
of that.
Okay.
Yeah, I think we cannot basically generalize all
Mm-hmm.
because again, like I mentioned before, each contract have their own nature.
Yes.
Each contract have their own objective, and
Mm.
also each contract have their own basically comfort level between each party. Sometimes a party is stronger than another party, then
Mm.
this party really need the business from that party.
Yes.
So
Yes.
they
It's
will
all
busy.
negotiation power. Yeah. It's all the bargaining
Yeah,
power, right? Between
it's all about the
parties.
bargaining power.
Okay.
So the spectrum is quite huge.
Mm.
It's more on how the legal counsel have a very strong analytics by communicating to all the stakeholder
Mm.
to get a sense on how the main objective of this contract can be done.
Mm.
I think that will be the main point for it.
Okay. Yeah. So we would like to achieve good outcomes for all the contracts.
Exactly. Yeah.
And so communication is key, and also to ascertain the forum and where the business is actually being held. directly.
Exactly.
Okay.
That's perfectly. Yeah, I think you summarized it really perfectly. Yeah.
Okay,
Yeah.
thank you. Is there anything you would like to share with our young audience? Because I presume people who are new to Indonesian law in companies are either very junior legal counsel or they've not encountered Indonesia in the course of their work. Maybe their companies are expanding into Indonesia or to expanding into business relationships with Indonesia.
Yeah.
Is there any other things that you might want to share with them so that they don't, encounter a pitfall in terms of,
Okay. So
negotiating their contracts?
yeah. So basically, to have a shortcut of it,
Mm-hmm.
you can select a good, reputable legal counsel
Mm.
to help you if you are doing on the first stage,
Yeah.
right? Of course, if you're doing on the first stage, you still don't have a in-house legal counsel in Indonesia, so you're still doing it. Of course, at that certain point, you will need a guidelines
Yeah.
from Indonesian law firm. At that sense, that is quite crucial to select Indonesian law firm that actually understand the way of thinking of a business, the way of thinking of a in-house counsel, and the way of thinking on how to ensure the compliance is being met.
Mm.
And after that, if the company actually already established and they already have their own in-house legal counsel and so on and so forth, I'm going to go. The biggest advice that I can give to the Indonesian counsel will be probably with other counsel. That is something that young legal counsel need to have the principle in their head from the start that they need to start to collaborate because they must.
Mm.
Otherwise, the product will not be, you know,
Yeah, it would be fatal to the transaction. Okay. So the role of legal counsel is not just to sign the document, make
no.
the clauses okay, it's to facilitate that communication and
Yes.
collaboration. Yeah, and
It-
everybody takes ownership, as you mentioned.
Exactly. And it's mandatory for the
Okay.
sake of the company.
Okay. Thank you so much for sharing that. What is one piece of advice you would give to them dealing with Indonesian legal counsel?
Dealing with Indonesian.
Or in your course of your experience as a legal counsel, is there any mistake that you made, dealing with the Indonesian regulatory regime?
Oh, okay.
Yeah. Is there anything that you
I
think
think, yeah.
might be useful to them?
The mistake that I have is something that the advice that I already given before.
Okay. Yeah. So you mentioned, I'm sure we've been distilling from you pieces of your experience, right? Your lived experience.
Yes.
Yeah.
So I was like in the ego of, I'm a legal, so I can. This is my product. I need to make it by my own perspective, which is so wrong in so many levels. And at the end of the day, the consequences is significant.
Yeah. And
Yeah.
legal has to clean up after that, right?
And yeah, we need to clean up after that. So that is quite an expensive lesson. So it's okay for us to be creative. It's okay for us to be thinking out of the box, and it's totally fine. And it's good, but do remember to collaborate, and do remember to see what is the market practice is. Do remember on the what is the nature of the business, in order for your contract is to be correct and in line with the industrial practice, both in international level and also in Indonesia.
Okay.
Yeah.
Thank you so much for that. That has been very helpful. We've learned a lot from your personal experience and also your professional experience
Thank you
being
so
with the
much.
regulators. Thank you so much, Kalfin, for being on our podcast today. Is there anything else you want to share with us on this podcast before we close this session?
Okay, thank you, Nicole, for the opportunity for us to come to the podcast. And of course, if anything that one of the audience or the audience want to have a further elaboration of explanation from our end, we will be very happy to assist, both for the legal counsel and the company, basically to ensure that the smooth of their business at Indonesia and their cross-border transaction is being done in a professional matters in the hands of Arianto and Partners.
Thank you so much. We're very honored to have Arianto and Partners and yourself join us today on this podcast.
You're very welcome. It's been an honor for us.
Thank you. I hope you enjoyed the discussion.
Thank you.
Thank you so much. If you have found this episode useful, catch the other episodes that we have. This has been Regional Counsel, a video podcast series presented to you by the Singapore Academy of Law.